This podcast is brought to you by the School of Advanced Study, University of London.
Good afternoon, everybody. Thank you for the invitation to speak to you this afternoon at this very interesting conference about the continuing impact and legacies of empire. Were I speaking in a New Zealand setting, or for a start I wouldn't be allowed to, if I was on a Maori meeting place, I wouldn't be allowed to use notes. I would also be obliged to observe Maori protocol and to give what is called my whakapapa. My whakapapa is the genealogical association that one has with the group before whom one is speaking. Whakapapa relates to kin, so that you can connect genealogically, so that if you have a genealogical kinship association through marriage or blood, that means the arguments you're about to have will essentially be a family argument. So it's a way of containing disagreement. An alternative form is known as kaupapa, which is a more purpose-led basis of meeting, and I guess essentially that is why we are here. However, I'm going to give you something of my whakapapa as a way of leading into the material I want to talk about today. My father was a practicing solicitor in a small coastal town of New Zealand called Gisborne, where he specialised in work that nobody at that stage wanted to do, which was working on Maori land. Eventually he was appointed to the bench after building up a very substantial Maori land practice on the East Coast, and soon after my mother died in a car accident, he was appointed to the Waitangi Tribunal, which is the New Zealand Land Claims Tribunal, which had recently had its jurisdiction extended from hearing contemporary claims of Maori against the Crown to considering historical claims. My father chaired the tribunal in its first historical claims hearing concerning the so-called 7 tall trees covering most of the South Island of New Zealand that led eventually to legislation in the mid-1990s in the Ngāi Tahu settlement. So my dad has been closely involved in this area. I've continued, I suppose, in the family interest in business. I completed my LLM in Canada during the early 1980s, which was a very formative period in the legalism of Aboriginal peoples, particularly in the white settlement colonies, former colonies of Canada, New Zealand and Australia, as I'll explain in a moment. And then, as the introduction indicated, I completed my PhD in Cambridge during the 1980s. My Cambridge PhD concerned what was then regarded as essentially a very highly specialised niche area. It was an argument called Common Law Aboriginal Title. It was an argument that a group of legal academics were making at the time, given the inaction and stagnation on the political front. Indigenous peoples, Canada, New Zealand and Australia had been making claims against the Crown. Political parties, mainly Labour parties, had committed themselves to setting up statutory land claims bodies, but began finding that these statutory bodies would come at some electoral penalty. So they started disowning or discarding the policies at the same time as academics started developing the common law argument. Myself, a couple of Canadian academics, Brian Slattery, who was my LLM supervisor, Kent McNeil, and an historian in Australia called Henry Reynolds. This led to some important cases, and eventually what was an academic argument became a very substantial jurisprudence in the courts, in very many respects a disfigured jurisprudence it's turned out to be. This occurred during the 1990s, particularly in the courts of Canada, New Zealand, Australia, the very famous Mabo case of 92, and the Richtersveld case in Southern Africa a few years after that. So my initial expertise has been in this common law field of judge-made principles of Crown liability, or at least of Crown responsibility before the courts for its treatment of assets, land in particular, traditionally occupied and used by Indigenous people. The most dramatic moment for that, at least for me personally, was in 2003 when the New Zealand Court of Appeal endorsed an argument I'd made in the 1980s that there were residual property rights around the coastline of New Zealand. This led to the Ngāti Apa the Ngāti judgment, but it also led to a very, very, very major political controversy in New Zealand that resulted in the splitting of the historical alliance between the Ratana Party, the Maori Party essentially, and the Labour Party, formation of two Maori political parties, and a empowering, if a fragmentation can be empowering, in the new politics of MMP. It was a very empowering fragmentation that occurred. I've also been a legal historian, because as one gets involved in this field, one necessarily gets drawn into the history of it. And there the particular influence has been probably New Zealand's most important figure in the humanities, a political historian thought called John Pocock, who's certainly well known to historians of political thought. Pocock and Quentin Skinner and others of the so-called Cambridge School view the history of law as a form of political discourse and contestation. And so we develop histories of law in terms of the way in which it meshes with and becomes a specialised language of a broader, more general political argumentation. And it is that kind of perspective I'm going to give on the shape and the legacies from the Imperial and Colonial Era in the white settlement, in former dominions, New Zealand, Canada, and Australia. Basically speaking, I'm going to divide this and compartmentalize them, periodize, into 5 eras, just for simplicity of analysis. Of course, it's much more complicated historiographically than that. The eras are going to be the Imperial Era, the Colonial Era, the post-war era, the new legalism that came in the period I spoke of in my introduction, the fin de siècle legalism of the 1980s and afterwards, and contemporary legacies and challenges. I'm going to look at the position of the Aboriginal peoples of Australasia and Canada, maybe with some side reference to the United States as we go along. These are Aboriginal peoples, of course, who have been in the context, well, not in the context of what international lawyers have called blue water colonisation. That is to say that they have not experienced the decolonisation that occurred during the 1960s and after in the era of self-determination. So Aboriginal peoples substantially remain in the colonial condition. The Imperial Era essentially begins after the Napoleonic Wars, 1815, with the so-called explosive colonisation of the Anglo world. Particularly the High Imperial Era is essentially the 1830s through to the 1860s, before the settler governments start acquiring self-government. During this time, the period of governors, London's control of native policy, because it was regarded as an imperial interest, to be overseen through James Stephens, Herman Merivale at the Colonial Office, advising the various Secretaries of State. These relations were conducted through the prerogative powers of the Crown, involving power to issue land grants to settlers, to control the domain of the wastelands, the meanlands of the Crown, administration of justice, and the constitutional role of the Crown as parens patriae. So those prerogatives meshed into the so-called formula that became adopted in the Imperial Era of protection and civilization. The protection was the deployment of the various prerogative powers in particular settings and in particular incidents and episodes. So protection involved the deployment of prerogative powers for the interim temporary protection of the tribal collective interest pending their civilization. If protection spelt out a current policy, present measures, civilization was the end point, the destination, which involved atomization of tribalization, detribalization, assimilation, and tribal peoples transformed into self-regarding, liberal, democratic citizens exercising the franchise, owning their own property in a nuclear atomized kind of a basis. So protection and civilization was the kind of formula that we see appearing from the 1830s. The 1830s, the era of abolition, finally, and also the resurgence of evangelical fervour and practice in the United Kingdom, the rise of Aborigines protection societies, church missionary societies, Wesleyan mission societies, this evangelical fervour of spreading the word of God and of actively transforming Aboriginal peoples and tribal peoples into basically citizen farmers. That was what civilization entailed. Meanwhile, the collectivity, the tribal interest would be protected through the Crown's prerogative meanwhile. So we have interim protection with eventual civilization. That was the imperial approach and the legalism of that time. During the 1860s, the settler legislatures finally acquire legislative and executive jurisdiction with regard to native policy. They start passing statutes that rehouse and enlarge the principle of Crown discretion. The prerogative was based upon 18th, 19th century ideas of prerogative, which is the Crown is regarded, in the words of a famous case, the supreme arbiter of its own justice. It is non-reviewable discretion, at least in the contemporary sense. Nonetheless, it's a highly disciplined. It's highly disciplined through the rise of the administrative state discretion, but nonetheless, it's an unreviewable discretion. We find the notion of an unreviewable discretion put into the Indian Acts in Canada and into the Maori Land Acts in New Zealand and the Welfare Acts in Australia. These take slightly different angles and approaches. For example, the approach taken in Canada, beginning with the Gradual Civilization Act of 1857 and the United Canadas, was a policy of enfranchisement, of individual Indians becoming equipped to vote by passing certain tests and standards. Of course, it didn't succeed, but that was the idea. So it was an enfranchisement, as it were, of civic status. Whereas in New Zealand, individualisation occurred through the imposition of a tenancy in common upon the collective ownership, fragmentation of title, so that each owner could enter into contractual arrangements, mainly involved alienation of their interest. So in New Zealand, the tribal land ownership became severely fragmented because of the passage and transmission of title through successive generations. In Australia, a kind of welfarist approach during the late 19th century was taken by the Australian colonies pre-Confederation. It was a welfarism that was more protection than it was civilization. It but it took a racial analysis towards eligibility. It was based upon basically government support of mission statements and outposts. So those were the regimes that were substantially in place until, well, some of them, they are still substantially still in place. Those are the legacies of empire and the colonial era. The fragmented, the highly fractured tenancy in common of Maori ownership, land ownership in New Zealand, which comprises now about 10% of the country. The Indian Act in Canada. The Indian Act gives very, very strong discretions to the Minister over the administration of reservation land, controls elections, band council status, and what have you. And in Australia, the welfarism is still pervasive under the old pre-Confederation legislation. Aboriginal peoples made a massive, as indeed the Caribbean and the Indian members of the Commonwealth made a massive contribution to the fight against fascism during the Second World War. So strong was their contribution in most of these jurisdictions that, and they're fighting alongside, for example, the Maori Battalion, famously, the European soldiers. It was thought that we should not allow the situation to continue anymore. They should have and be given full equality. Now, the paradox was that after World War II, policies of removal and termination were adopted by people like Pierre Trudeau in Canada, Paul Hasluck in Australia, in order to remove what they saw as the barriers of full citizenship for Aboriginal peoples. So the protective mechanisms, the regimes to which Aboriginal peoples had developed, a kind of modus vivendi, a love-hate relationship, Maori land laws in New Zealand, the Indian Act, that was proposed to completely remove those protections, the interim protection that had lasted over a century, and instead to individualise ownership and to remove all impediments to full civic participation. The Aboriginal response to these proposals was strong and it was vigorous. Aboriginal peoples were required to articulate a response to these uber-liberal policies and thinking. So they drew on international law. Public law was also developing in that direction at the time through notions of judicial review. And so they were able to develop a concept of aboriginality. And aboriginality became the basis by which the Crown in these countries addressed land claims and started developing regimes to deal with the new legalism that was defined by this concept of aboriginality. Now, aboriginality has meant that, and this marched alongside developments in international law. So finally we had legal mechanisms prepared to recognise the collective, the tribal, rather than trying to detribalize and assimilate. And this has been the very fraught and problematic legalism of the 1990s and into the new century. Aboriginal groups develop particular relationships with the Crown based upon the particularity of their claims, their geographical setting, and the historical pattern of relations with the Crown. So we have a patchwork, we have new buzzwords and phrases that animate the legalism, like capacity building, settlement entities, governance entities. These are becoming the new challenges that Aboriginal peoples are facing. For some groups, they have been invigorating, and they have been challenges to which many have risen. But then others deride McTribe Limited, the rise of tribal corporatism as well. So these have not been developments that have been regarded as unproblematic within Aboriginal communities. The other groups have found, for example, in Australia, the requirements for prescribed bodies corporate under the native title legislation, the filing of accounts, the transparency that's required is particularly onerous given the lack of human resources and background that they have in this. So from going from an area of high discretion, tribal peoples now find themselves in situations of high and intense, complicating, and sometimes heavily contested legalism. Some groups have been making advances, some groups have been finding it difficult. But the outcome of this is that some have broken free from the legacy of colonialism into a form of corporatism. Others still find that they are inside the mentality of the old regimes that were imposed during the colonialist era. I'll leave it at that. Thank you. I've run out of time.